Ko tubua te kawa, ko tawhito te kawa, ko te mātoi o te rangi tēnei rā te taketake. He runga mārua atu mā wakaeketia ki runga. Ko oru koe o ka tupuria, he ka waura, he ka waura. In August 2014, Te Ati Haunui a Pāparangi signed a deed of settlement with the New Zealand government, which settled the long-standing claim our people have had over the Whanganui River for over a century and a half. The Whanganui River is the third longest river in New Zealand, at just over 300 kilometres in length. It drains approximately 7,000 square kilometres of geologically young and therefore erosion-prone hill country. The Whanganui rises on the western slopes of the Kawa, the mountains of the central volcanic plateau, where the headwaters have been tapped for the production of hydroelectricity via the Tongariro power scheme since the 1970s, something our people were not consulted over and continue to oppose. Beginning in the 1880s, laws were passed to force the physical removal of pātuna and utupi aro, eel and lamprey wares, to allow for the passage of river steamers into the interior of the North Island. In doing so, the government embarked on a less than subtle program aimed at undermining the reliance on, and therefore relationship, that the Whanganui tribes have had with the river for over 1,000 years. When I consider the history of Whanganui claim for the river, it has always essentially been about the same ancient edict of our old people. Kaua kai kōrero mō te awa, kōrero ki te awa. Do not merely speak of the river but address it directly. In March 2017, legislation was passed in the New Zealand House of Representatives that supported at law tupua te kawa, the innate values of the Whanganui River, as understood by the indigenous peoples of this river. The result of the negotiations with the New Zealand government was to accord the Whanganui River the status of legal person. The Whanganui River is now known as Te Awa Tupua. We think it's really important to understand that legal personhood is really only the vehicle for carrying the fundamental rights of nature. The innate values of Te Awa Tupua have been supported at law through this legal person. So if we take this view of the river, it's from the upper reaches, virgin forest, and the waters are clear and clean. And we're reminded that the river is both a physical as well as spiritual entity. So the first value that is part of the definition of this river now is ko te awa te matapuna o te aura. The river is the source of spiritual and physical sustenance. So we have an emotional attachment with our rivers. We have a spiritual attachment, and all peoples can understand and share that. The second value is indivisibility. E rere kau mai te awa nui mai te kāwi maunga ki Tāngata. The great river flows from the mountains to the sea. If we are to address the river's issues, we must address it as a whole. If we are going to address what is best for the river, we must address it in its totality. We can't address it through its compartments. And I use this image because the child in the photograph is my paternal grandmother, and those are the people who adopted her and brought her up. They come from other parts of the river, and rather than viewing her as a subset of the whole, they brought her up and treated her as the whole that she is, the whole child that belongs to the whole tribe. And so it's a good example of an indigenous way of thinking, of viewing somebody as a whole, of being able to view the river as a whole at the same time. And it's from that basis that we start to address those matters and those issues that afflict our river. And so this picture is of the old people who took the claim for our river beginning in the late 1920s. The third value relates to the place that indigenous peoples have on our river, our tribe's long-standing relationship with the river, which is innate. We are inextricably intertwined and aligned with our river. We are the river and the river is us. So this journey has been a long one. but it's been one based on some fundamental principles. And so if we consider the river as both physical and spiritual, is indivisible, that indivisibility relates also to its indigenous peoples. That gives us a solid foundation to move on and include the rest of our community in the thinking. And so this next image represents the communities coming together, the indigenous community, the non-indigenous community around Te Awa Tupua, this new status for the river. And it speaks of the small and large streams that flow into one another, ngā manga iti, ngā manga nui e ono kawana. They flow into one another and form one river. And so really it's a call for all communities to come together under the definition of this new status for the river, this new legal person. So it's an inclusive proposition. Peoples of all identities are included because they use and live with the river, and so they're responsible for it. The paradigm has shifted to indigenous values, to viewing the river at the centre of our relationship with natural resources, but nonetheless it speaks of our obligation to work with the river and work for it fundamentally, and then it can provide for all of us. So really that's it. Those four values called Tupua Te Kawa define this new legal person. And it's really the values are the important thing to understand, because those values are the values that we want all communities to adopt. Indigenous values, but ones that are shared in the best interests of our river. And in doing that, we're according our river rights. But we're also stating that fundamentally the ones that need to uphold those rights are all peoples that use and interact with that river, regardless of whether we're indigenous or non-indigenous. We fought for 150 years or more to have our indigenous view recognised at law. The law is a vehicle. The driver are the fundamental values that we express as indigenous peoples on a daily basis. Tihei mauri ora, ki te whai au, ki te au marama. Kia ora.